Contempt of Court. The Contempt of Court Act, 1971, defines the expression contempt of court as follows. According to Section 2, contempt of court may be either civil contempt or criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ or other process of a court or willful breach of an undertaking given to a court. Criminal contempt means the publication, whether by words spoken or written, or by signs or by visible representations or otherwise, or any matter or the doing of any other act whatsoever, which 1. Scandalize or tends to scandalize, or lowers or tends to lower the authority of any court. 2. Prejudices, or interferes or tends to interfere with the due course of any judicial proceedings, or 3. Interferes or tends to interfere with, or obstructs or tends to obstruct, the administration of justice in any other manner. The following acts are, however, not contempt of courts. A. Innocent publication and distribution of any matter. B. Publication of fair and accurate report of judicial proceedings. C. Fair criticism of judicial act. D. Complaint against presiding officers made in good faith. E. Publication of fair information relating to proceedings in chambers or in camera. Under the Act, contempt of court is punishable with simple imprisonment for a term of 6 months, or with fine which may extend to ₹2,000, or with both. A judge, a magistrate or any person acting judicially shall also be liable for contempt of his court in the same manner as any other individual is liable under this Act. Thus, judges have no general immunity from criticism of their judicial conduct provided it is made in good faith and is a fair criticism of his judicial act. The terminology used in the definition is borrowed from the English law of contempt and embodies concepts which are familiar to that law which by and large was applied in India. The expressions scandalize, lowering the authority of the court, interference, obstruction, and administration of justice are therefore to be understood by our courts with the aid of English law. In Bardakant v. Registrar, Odisha, AIR 1974, the appellant, senior judicial officer, was convicted and sentenced under the Contempt of Courts Act, 1971 by a full bench of Odisha High Court. The facts of the case were that on 28 March 1971, a disciplinary proceeding was started against him and he was placed under suspension. On receiving the suspension order, the appellant wrote 3 letters to the High Court and 1 to the government. It was the contents of these letters on which the present contempt proceedings were launched against him, and he was punished. The Supreme Court held that contemptuous allegations made with reference to the administrative functions of High Court amount to criminal contempt. Administration of justice is closely associated with the Court of Justice, which have to perform multifarious functions for due administration of justice. Any lapse from the strict standards of rectitude in performing these functions is bound to affect administration of justice. The whole set of a court is for the purpose of justice, and the control exercised by a judge over his assistants have also the object of maintaining the purity of justice. It is, therefore, important for the superior court to be vigilant about the conduct and behavior of the subordinate judge as a judge to administer the law. Adjudication of cases between parties is not the whole administration of justice. Disciplinary control is a function as conducive to proper administration of justice as laying down the law or doing justice between the parties. Thus, when the High Court under Article 235 functions In disciplinary capacity, it does so in furtherance of administration of justice. It was held that the defamatory criticism of a judge functioning as a judge even in purely administrative or non-adjudicatory matters amounted to criminal contempt. The imputations in the above-mentioned letters have grossly vilified the High Court and have substantially interfered with the administration of justice, and therefore the appellant was rightly convicted of the offence of the criminal contempt.